Welcome, everyone. It's wonderful to have everyone with us tonight. It's a very interesting program and a subject that those of us at the Upper Mississippi River region, ILO, are really interested in. I'm Mary Ellen Miller, and I'm your host tonight. I'm chair of the UMR, as we affectionately call it, the UMR board. Our focus is the upper part of the Mississippi River, with a primary focus on water quality as well as water quantity. So tonight we've got two wonderful women with us. I've had the pleasure of hearing both of them. I know you're in for a lot of really good information tonight. So with us tonight is attorney Katie Garvey from the Environmental Law and Policy Center. She's based in Chicago. And Elle Gadient, Delaware County, Iowa farmer, and also Iowa Farmers Union beginning farmer representative on the board. So wonderful to have both of you so engaged. We're going to hear tonight a discussion about the federal lawsuit aimed at abolishing Swampbuster provisions that protect wetlands on agricultural land. We'll look at the last bulwark of protection remaining after the Sackett decision gutted wetland protections in the Clean Water Act. And just a reminder that the Clean Water Act was passed October 18th of 1972, and Congress overrode the veto of then President Richard Nixon to pass the Clean Water Act. So quite a historic act, and we're certainly glad that Congress acted. We're going to hear a lot more about the impact on all of this, what it means for those of us interested in water issues, as well as what it means for the agricultural community and how it impacts their ability and how it impacts landowners. So, Katie, are you starting off with us tonight?
Yeah. Yep.
I'm going to turn it over to Katie.
Okay, so as Mary Ellen mentioned, Ellie and I are here to talk a little bit about this, what we refer to as the Swampbuster litigation. It was a lawsuit that was filed in the Northern District of Iowa, so in Cedar Rapids. And it was filed, here's the sort of cover page of it. It was filed by the plaintiff, which is an LLC called CTM Holdings. And it was a lawsuit filed against the US Department of Agriculture. And another player that's not really featured here on this screen, but that Mary Ellen already mentioned is last in 2023, there was a really big loss for wetland protection in the Sackett case that the US Supreme Court decided. That lawsuit was brought by a law firm called the Pacific Legal Foundation. And the same attorneys who brought the Sackett decision are the attorneys who are behind the complaint and the lawsuit that we're talking about today. So yeah, I'll just give you a little bit of background. As Mary Ellen mentioned, Swampbuster, now since the Sackett decision has taken place, is one of the last remaining sort of nationwide protections available for wetlands at the federal level in this country. And what Swampbuster is it's a 40-year-old Farm Bill program. It was part of the 1985 Farm Bill that basically says if you want to get certain farm benefits, you need to comply with these two pillars of conservation compliance. One is referred to as Swampbuster. The other one's referred to as Sodbuster. The two provisions operate the same way. They basically lay out the requirements that say if you have to comply with the following things, and if you do that, you're eligible to receive farm benefits. So I'm going to set Sodbuster aside for now, and we're talking about Swampbuster. And what Swampbuster does is it says that you cannot drain, fill, or convert wetlands and then use that wetland to grow an agricultural commodity. So Swampbuster doesn't say anything about converting your wetlands to build a home, build a road, grow timber, grow cranberries, grow fruit. Cranberries and fruit are not agricultural commodities. There's a lot of things that you can do with a wetland if you want to drain it and still comply with Swampbuster. And then taking a step back further, choosing to comply with Swampbuster is entirely voluntary. It's just like any other eligibility benefit that you need to meet in order to gain access to federal benefits. So it's not uncommon for when Congress decides to open the purse and give out money that they decide to apply some strings to that. So you usually need to meet eligibility requirements anytime you're going to get federal benefits. So for example, Medicare, there's one of the eligibility requirements is you have to be over 65 for the most part. Same thing here. Complying with Swampbuster and Sodbuster is just one of the many eligibility requirements. And if you meet it, you can get access to farm benefits. If you don't want to comply with Swampbuster, then you're free to do whatever you want with your land. There's no penalties and no action will be taken against you. Now, the way that I've just described it is based on my understanding of how Swampbuster works, based on my review of the law, and based on the U.S. Department of Agriculture's view of the law and the government's view of the law in different filings they filed in this lawsuit. And we'll hear from Elle too later today, who is an actual farmer. We can hear how she views it. The plaintiff in this lawsuit views it very differently. So this is a quote taken from the press release of the law firms when they associated with this lawsuit. And you can see that they characterize Swampbuster as violating farmers' rights by taking private property without just compensation and by conditioning the receipt of federal benefits on the waiver of a constitutional right. Now, I'm not going to get into the sort of merits and legal arguments. I'm happy to send our briefs if you guys want to read them. But what I will say is that depicting Swampbuster in this way is sort of like depicting Medicare as violating people under 65's constitutional rights as some sort of reverse age discrimination. It only makes sense if you don't understand the program and don't understand how it operates. And the other thing that I just want to highlight here about the way the plaintiffs frame this lawsuit is you can see they frame it in the words of farmers' rights. But the plaintiff, this is a document here in the plaintiff's own words. We asked the plaintiff to describe his occupation and employer. He did not say that he is a farmer. He is a business owner running several companies. He's self-employed. So you might be wondering, what is he doing filing a lawsuit challenging this farm program? Well, he owns land in Iowa, which he rents out to a tenant. And he, when he first purchased the property, he was part of a program called CRP, a Conservation Reserve Program, which was it's one of the many USDA farm benefits under which farmers sign a contract with USDA to basically not farm certain land. So land that is wetlands or land that is highly erodible. And in exchange for not farming that, the government pays you monthly rent payments effectively. So when the plaintiff here purchased the land, he moved into the shoes of that contract, which had 2 more years on it. The CRP contracts are usually 10 years long. But as of September of last year, he no longer has a CRP contract, and so he no longer receives any farm benefits. So it's not only is the plaintiff not a farmer, but he doesn't even receive farm benefits. So it's not really clear how he has any standing or ability to bring this lawsuit. So we, ELPC, my organization, represent Iowa Farmers Union. And then we intervened in this lawsuit with a coalition that also involved the Iowa Environmental Council, Food and Water Watch, and Dakota Rural Action, which is a South Dakota-based farmer group. And we got involved, and Iowa Farmers Union got involved because they care deeply about these farm programs, and they don't want to see them invalidated and destroyed. And they believe that conservation is important, and that farmers who protect the natural resources and conserve the land should be entitled to receive benefits, and farmers who are not going to invest in natural resources should not be entitled to those benefits. And Elle, is not only is she a farmer, but she's actually a farmer who lives 12 miles from the land owned by the plaintiff here. So she would not only be indirectly affected by it, but she would be directly affected by it. And we'll hear from her a little bit more about how that impacts her. But just to talk about the indirect impacts, this is a chart that shows EPIC awards. So EPIC is another farm benefit program. I just picked one of them. There's many of these types of maps that have been developed. And this shows you state by state what percentage of qualified applications are actually granted a farm benefit program money. And you can see in some places it's under 20% of the qualified applicants will receive the money. And that's because there's not enough money. So already these programs are oversubscribed. There's not enough money to go around. And so removing the requirement that people need to comply with Swampbuster and Sodbuster would make the competition that's already really steep for these type of programs and really just make it even more steep. Again, I will not get into the super nitty-gritty details of the legal claims, but I've written out the plaintiff's 5 claims here. And then I'm just going to give a quick sort of overview on the status of the case and sort of how that's progressed. The complaint was filed in April 2024. Iowa Farmers Union and the coalition that we represent filed to intervene in the case last October. Now, intervention, what that is basically when there's 2 parties to a lawsuit, most of the time people don't want to get involved in lawsuits they're not already involved in, right? But the Farmers Union and Dakota Rural Action and others realized that this was a really important case and there was a lot on the line. So we asked the court to allow us to intervene in the case, which basically says we become formal parties to the lawsuit. So we filed that motion last October. There was argument in November, and we were granted intervention in December. So that was the first sort of hurdle. Now that we are part of this lawsuit, there's lawsuit things going on. So there was first, the plaintiff filed what's called a motion for judgment on the pleadings, which is basically a very preliminary motion that says, hey, look, you don't need to go any farther. You don't need to have discovery. We don't need to learn any facts. All you need to do is look at what's been filed already on this case, and you can say, as a matter of law, we win. So plaintiffs filed that motion. It was denied a month later. And now we're at the stage where the parties have exchanged what's called discovery, which is you're allowed to ask each other questions. You're allowed to ask for documents that are relevant to the claims. And then once all of that information and evidence is gathered, the parties move for what's called summary judgment. And you basically say to the court, here's all the evidence that shows we win as a matter of law. And so please grant our motion for summary judgment. So the case is in that process right now. We're in the middle of a briefing. It'll be done briefing by early March, and the court just set oral argument for the end of March. And then here I just put a few pictures of different wetlands in Iowa here, just to have some imagery. So with that, I'm gonna close this out and pass it over to Ellie.
I am Elle Gadient. I'm a farmer in Delaware County. Like Katie said, I'm just 12 miles downstream of the farm in question, or the farm who the owner is leading this case. And I was introduced to this case by the Iowa Farmers Union. I'm a member of the Iowa Farmers Union and also the beginning farmer representative. And they have wonderful, great communications and keeping us updated on things going on in Iowa. And it really flagged my concern when I saw Delaware County, because I am a Delaware County farmer, and looking more into it, realizing that I'm directly downstream from this wetland in question that could be drained or they're looking to change. I grew up on a farm in Dubuque County, so eastern Iowa as well. And my husband grew up on the farm that we're on now. And I want to share my screen just to show a little bit more of the farm that my husband and I are in the process of buying, where we live, where he's rented, and that's directly downstream. So here we are the fourth generation of Beslers in the family taking care of this farm in Delaware County. So here I have a few pictures of the current generation and the last generation. This is my husband Steve's dad. It was a really crazy phenomenon. They had triplet calves one year when Steve's dad was growing up, and anyone who's raising cows, especially with natural insemination, triplets are very rare. So a little bit of history and a little preview on life on the farm. And then here's one of the old pictures of the farmstead looking over at the barn. You can see the dairy cows ahead. This is my husband Steve when he was little. We were both cow lovers, and either one of us, if our parents didn't know where we were, of course, independently, we could usually be found with the cows. Steve at his favorite place with the cows, growing up with animals. Here's Steve's parents in the farmhouse kitchen. What you can't see in the picture is they're preparing a holiday meal, showcasing it. And then here's Steve with his dad. Steve grew up always wanting to be a farmer. He's the youngest of 7 kids, and his dad was the youngest in his family as well. And his dad had the opportunity to buy the farm. So all of his life, his dad and mom had said, well, if you want this someday, you'll have the opportunity to buy the farm. This was Steve's dream from a young age. And I show this to really paint the picture of how much we care and how deep this love for our farm and my husband's family farm runs. And this is just 2 generations, but there's 2 generations before as well that tended to the land and worked hard to try to leave the land better than they found it, to create more opportunities for the next generation. And we're facing a time where opportunities for the next generation in farming feel very challenging, with farmland access, with the price of farmland, artificial increases in farmland pricing. And something about this case that really grinds my gears is I believe farmland should be owned by farmers, and this person is an investor renting out to a farmer, which is limiting farm ownership access in the community. Just one thing that irks me about this. But I'm painting this picture to show our love. And then my next slide is the farm over the summer. This is overlooking our hay field. We have some pasture bales here that we have some grasses that we bale and sell locally, and then you can see the farmstead above. And I love being here. I love farming. I love thinking of our future here. And a few things that we do to better the land, better opportunities for ourselves is, you can see these are really mild slopes. So I grew up closer to the Mississippi River, and the hills on my family farm are like this. In our area, this is a little hilly. See these gentle slopes? Slopes are more erodible land. So of course, if there's a heavy rain, if there's a slope, that's more likely to wash out. And you can see here where we have slopes, we have that ground either in pasture or we have it in alfalfa, because that's having permanent hold in the ground, reducing erosion, helping also with the water infiltration with the rains. And then farther down the field, we rotate corn and soybeans that we sell locally. We dream of soon getting our own cow-calf herd and putting fences back in. Steve was a dairy farmer up until 2019, and both of us look forward to having cows back in our lives. So all of these things together are sharing our love. So showing that pasture and talking about dreaming of our futures here. So Steve and I are in the process of buying his family farm now. We are closing this month. We're super excited. And through that process, we've been working with our local USDA, the U.S. Department of Agriculture office, to access a low interest loan, a beginning farmer loan. It's called the participation loan. It's just one tool that the government has for us, a resource to help farmers get into farming, and especially help beginning farmers. Even with this, it's super challenging and prices are still really high and there's lots of external factors at play. But one thing with this loan that we applied for was we had to meet the criteria. There's eligibility set, parameters set to ensure that this loan is going to actual farmers and that they're farmers who will meet guidelines. Really, it's like minimal requirements that will do the right thing. And one of those is you have to abide by Swampbuster and Sodbuster. And I think these are imperative. We have to have requirements that farmers are going to do at least a baseline of what is necessary for taking care of our natural resources, taking care of the land, our environment, water quality to access resources. Of course, we could have gone another route. If we didn't agree, we could have went with solely with a commercial loan, but we were interested in participating and seeking these resources, and in doing so, we were required to abide by the guidelines set. That's my tie-in to the case. So I'm personally invested because I'm downstream. I'm personally invested because I'm a farmer. I'm personally invested because I'm an Iowan. I care about my local community. I care about the health of my neighbors. Iowa, sadly, is the second highest cancer rates in the country. And I don't support that. And I don't support practices that further worsen that situation. And I think in this case, it can seem like, oh, this is just a little stream that's really far away from me. But this stream does eventually flow into the Mississippi River, down to the Gulf of Mexico. And so this isn't either just about a Delaware County case. This is all farm program access. The change in Swampbuster and the eligibility requirements could really make big changes. And I want to ensure that farm resources and farm programs it's required that you have to be a farmer to be accessing them, and you have to be doing what is right to access these programs.
I want to start out with a little bit of clarification. Katie, in the this is a little bit in the weeds, but Northern District of Iowa, Eastern Division, U.S. District Court. Well, 3rd District, you mentioned that court actually is in Cedar Rapids, Iowa. One judge, a panel of judges. How does this work?
Yeah, I'm happy to get into the weeds if you have questions. I just assume I never want to get too far into the weeds, but I love the weeds. So yes, so the Northern District, the District Court of the Northern District of Iowa, Cedar Rapids Division is one of many, many dozens of district courts across the country. So these are federal courts, and they are what are called courts of first impression. So this is if you're filing a lawsuit that has a federal hook, you file it in a federal district court. From there, we've probably heard of courts of appeals. So whoever doesn't like how things happened at the district court, it goes up to what's called the Court of Appeals. There's 12 of those across the country. In this case, the Iowa District Court goes up to the 8th Circuit. And then above all of those appellate courts is the Supreme Court. So the district court, Iowa has, I think, a northern district and a southern district. So they have probably 2 courts, I think is the total. And the states have, some states have many more than that. Some states have only 1 or 2 district courts. And the way that the district courts usually work is that a lawsuit is assigned to 1 judge. Now, there are cases where it could be assigned to 2 judges sort of at the same time. And that is the case in this lawsuit, which is our case got assigned to the chief judge of the district court. His name is Chief Judge Williams. And then it got, and this is a somewhat common thing, is when the parties are at a very preliminary stage and they're going through that early stuff, the discovery I mentioned, like exchanging of evidence. Sometimes they will, the district court judges will refer the case to what's called a magistrate judge, and the magistrate handles those sort of preliminary things. So the magistrate judge in this case handled the intervention motion that we filed, but now that we're sort of past that preliminary stage, it's sort of back in the district court judge's hand. So it's 1 judge will be making this ruling, and then, you know, if it ends up getting appealed, it usually goes up to the appellate court level. They usually do, there will be panels involved at that point, usually a 3-judge panel at that point.
The district court judges are federal and they're appointed by?
They are appointed by presidents.
By the president.
Yes.
And do we know what president appointed this chief judge?
Yes, both the chief judge and the magistrate judge were first-term Trump appointees. I think they've been on the bench since about 2019-ish, I think.
From his first term?
Yeah, correct.
Okay. Okay.
And if, oh, sorry, I didn't want to cut you off, but there were a couple of things that came up when Elle was talking that I wanted to make sure I just highlighted too.
Mhm.
But okay, which is the lawsuit is specifically about this particular piece of property that this Chicago attorney owns in Iowa. And it is about, and if he fills and drains his wetland, that will have direct consequences on people like Elle who are downstream of him, because wetlands hold water. And if wetlands are gone, there's nothing to hold the water there, right? And the water has to go somewhere, and it goes downstream. And so it is very local, and it is happening in Iowa, and that's all true. But if the plaintiff wins this case, Swampbuster is gone across the nation and it doesn't exist anywhere. So the protections that are currently in place on this particular land will be gone everywhere. So that was just one thing I wanted to add. And I also realized I didn't do a very good ode to wetlands, but to the extent people don't know, wetlands do amazing things. They provide natural habitats, they provide biodiversity, they help pollinate crops, they help with water quality and the cancer risks that Elle was talking about. They filter pollutants and excess nutrients out of water and help keep that out of the water that we drink. And they are really, really important flood mitigators. Again, if a wetland's there, it can capture and hold the water on the land, but if there's no wetlands to hold it, it's going to go somewhere. And the flooding, which is already really, really, really bad in Iowa and in a lot of places, and likely to get worse with climate change, is going to get significantly worse if people just start destroying their wetlands at a higher rate.
Let's talk a little bit more about this particular wetland. Who classifies it as a wetland?
Yeah, I can take that one, Elle, or I don't know if it's so all wetlands are classified by the U.S. Department of Agriculture, NRCS, Natural Resources Service. Yeah, I'm going to say the acronym wrong, but it's a department within the USDA. So they went around and did a lot of wetland determinations in the 80s when Swampbuster was passed, and they now do them if a farmer comes along and says, hey, I want to do this to this land, but nobody's ever told me if it's a wetland. Can you come and do a wetland determination for me? It's all done by the USDA and RCA.
And is this a wetland that is always wet with water, or is it one that ebbs and flows? In other words, some areas classified as a wetland actually can drain periodically or seasonally. Do we know the type of wetland in this particular farm?
Yes, it is a wooded wetland, and so trees grow on it. And we know that the plaintiff has logged timber off of his property, including the wetland, and sold it and earned $26,000 on the sale. So the idea that he can't do anything with his wetland is undermined by the facts of the case here, which is that in full compliance with Swampbuster, he chopped down the logs on it, left the stumps in place. And the reason for that is under USDA rules, keeping the stumps in place will maintain the structural integrity of the wetland. Whereas, and you can cut the top of the tree off, but you can't remove those stumps. So this particular wetland is wooded, and it is my understanding, the plaintiff alleges this, that it is one of the types of wetlands that is not wet year round, that it experiences periods of parent
why,
drought.
what would he want to do with it if it were not categorized as a wetland? What is his plan?
Well, so in the lawsuit, he alleges that he wants to be able to farm it. But the evidence that has been produced, and you can see this if you read our briefs, shows that his plan all along was actually not to farm it in the long term. It was to develop it commercially and sell it for commercial development.
Take out the trees, take out the stumps.
Yeah, take out the trees, take out the stumps, and turn it into commercial development, because this particular land is right on the edge of the town, the nearest town there. So it really is sort of at the edge of the town.
How does that, I was thinking that the argument was he could not receive any future conservation program contracts. But how does that play out? How does he want to, I'm trying to figure out what he wants to do, because I thought maybe he wanted to tile it and rent it out as row crop, but it doesn't sound like that's what he wants to do.
Yeah, I honestly don't know what's in his heart. All I know is in the complaint, he alleges that he wants to be able to drain it, dredge it, and then rent it out for row cropping. Evidence that he produced suggests that his plan all along was to sell it for commercial development. I have no idea what,
And he wants to do that while receiving benefits.
Well, that, again, in the complaint, that is the allegation. However, the plaintiff stopped receiving his CRP contract payments in September of 2024, so 5 months ago. And he no longer receives any farm benefits, as far as we can see. So it's not really clear to us what skin he has in the game. And that is one of the arguments that is in our brief, that there's a legal concept called standing, which is if you, we all have complaints, right? I got a lot of them. And just because I have a question that I think I'm right about and somebody else is wrong about, I don't get to just go to a federal judge and make them issue a ruling to me, right? You have to have these jurisdictional requirements. And one of them is that you actually have suffered or will suffer an injury. You have to have skin in the game. You have to have a personal stake in the outcome. And one of the primary arguments we made in our motion for summary judgment is given that the plaintiff doesn't receive any farm benefits,
doesn't plan to row crop the land, and has no reason that he needs to comply with Swampbuster at all anymore, he doesn't have any skin in the game and doesn't have standing. So that is the arguments that you would find in our motion for summary judgment.
Well, there are a couple of questions in the Q&A that kind of talk to this. Anonymous wants to know what the issue is with the stream. What are the requirements to access USDA funds? It sounds like you have to farm the land yourself, not rent it out. I don't think that's actually correct, right? You can receive benefits if you rent out the land.
So I am not a farm benefits expert. My understanding is one of the eligibility requirements for most farm programs is that you have to be an active farmer. I think it's actively participating in farming, I think is what it is. And even though this plaintiff, I don't believe ever was that and never has claimed to be, he did take over the CRP contract from the prior landowner who was a farmer actively engaged in farming. And that's pretty common that those sort of contracts move with the land and the new landowner will take over that farmland. So my understanding is that one of the other eligibility requirements is you have to be an active farmer. But again, I am not a farm expert. Yeah.
Let's see if
And
Elle answer.
And CRP is Conservation Reserve Program. And so you're not farming that land. Conservation Reserve Program is I am reserving this land just for conservation for native habitat, and it's not being actively farmed. And so I think I'm a farmer receiving benefits or working with these programs. I'm not an employee who knows these in and out, but it would kind of make sense if someone was not farming and had access to that benefit owning farmland, because you're not farming the land with that program, that land specifically.
Another question is, are non-agricultural wetlands in developed urban areas affected by Swampbuster?
They are not. Swampbuster only prohibits the draining and conversion of wetlands in order to grow an agricultural commodity. So if you want to build a hotel, if you want to build a house, if you want to grow cranberries, those things are not agricultural commodities, and you can do whatever you want and still comply with Swampbuster.
Okay. So another question from Carolyn is, would there be an opportunity for Ellie and her family to sue the landowner north of them if they fill in the wetland, which would deprive them of future water and maybe floods from weather-related climate impacts that would impact their property? So does Ellie have a position here, skin in the game, as you say?
Well, I mean, it definitely sounds like Ellie would have skin in the game. Whether that's a viable claim or not, I don't know. And it would be a totally different set of, it would be sort of a private lawsuit of individual against individual. And, that I feel like I'm in law school. It's like a law school torts exam question that I don't know the answer to. But I would agree with you, Mary Ellen, that Ellie would definitely have skin in the game, for a situation like that. I don't know if Ellie has any views on that.
And Ellie, you're downstream, correct?
Yes.
So how do you see this impacting you if he takes out this wetland?
Well, it could impact me and my neighbors, really the community, but changing the wetland, that water needs somewhere to go, which would change the flow of the stream, or potentially would change the flow of the stream. Also, as weather gets to be more extreme, we've been in drought, but it seems like we go from drought to flooding, and water absorption and just a place to hold water before it's rushing downstream. That's how I see it impacting us. Additionally, when there are heavy rains and the water needs to flow as it does down to the stream, if that stream level was higher because there's less water held upstream from us, it could not be, the stream may not be low enough for the water to be flowing off our fields as it does currently.
There's another question. I'm not sure I quite understand it, but Marty wants to know, can the zoning be changed for commercial development or residential? Some agricultural zoning in Washington allows 25% of farm property to be used for residential.
And
Would that be something he might be attempting to do?
yeah, I don't know. I have to admit complete ignorance on the zoning requirements of Delaware County. I don't know anything about it.
And also, I don't think anyone mentioned, how many acres are we talking about? The total farm, and how much is wetland?
Yeah, great question. The total farm is about 71 acres. 9 acres of that have been certified wetland.
Wow. It's a small patch.
Yes, and it is, my understanding is it's not just one patch, it's sort of, there's a stream that goes through the property, through the land, and there's patches of wooded wetland in a few different places. So it's part of an acre here, part of an acre there, a few acres here and there.
I have to say, I'm a little confused about what his intent is, because he no longer is receiving any benefit from the government for any conservation program. And somehow he feels he wants to do something that is not legal. And that's because it's a declared wetland. I guess I'm still not clear on why he can't do what he wants if he's not enrolled in an NRCS program.
I am as confused as you are, Mary Ellen.
It's an interesting, Ellie, do you have any thoughts about this? I mean, what he's trying to do here?
I feel that he's like ensuing the USDA, the U.S. Department of Agriculture, on him not having access to programs is like, he shouldn't really have access to programs, one, if he's not a farmer, but it's more of a kind of feels like an attack on farmers like me and farmers not only in Delaware County, but across the state and across the country who really depend on these programs to help us with conservation practices, or like me, help us purchasing land. And by this case is about eligibility. And if that were to change, my eligibility for programs like the low interest load or conservation programs could be limited in the future. And I feel that it's very unjust that he is taking this to court at all. And he bought this land knowing about the wetlands and about the provisions on the wetlands.
Yeah, and I'll just say that if you look at the Pacific Legal Foundation's press releases and coverage about the lawsuit, they really couch this as they're fighting for the farmers and that farmers' rights are being violated. But it is interesting because the plaintiff isn't a farmer, and there are no other plaintiffs in the lawsuit. The tenant who rents this land isn't part of this lawsuit. Elle isn't part of the lawsuit. In fact, not only did they not find a plaintiff who was a farmer to be part of this lawsuit, the Iowa Farmers Union, Dakota Rural Action, and other farm groups feel so strongly that Swampbuster needs to be preserved. They intervened as defendants in a federal lawsuit to make it to stop the action. So, yes.
My skepticism might show with my next question, but is it just possible that Pacific Legal Foundation was scouting for the right opportunity to challenge this law, and that they had trouble finding a case? Because I'm not sure how this holds up.
Yeah, I don't know what Pacific Legal Foundation's process is or was. There's there was a podcast that the plaintiff and the attorney from the Liberty Justice Center did about the lawsuit before, like very early on in it. And they made it pretty clear in that lawsuit, or sorry, in the podcast, that their goal is to get this to the Supreme Court.
Another comment that's pretty interesting. In Iowa, if someone drains a wetland, they must replace it with a different wetland. So they're creating a wetland somewhere else, but he's not offering to do this?
So Swampbuster, we've been talking about it in these sort of very broad strokes of like, it says generally you can't do this, you can't drain a wetland and grow an agricultural crop on it. That's the general. But like with anything in a law, there's a bajillion exceptions and exemptions and things like that. And one of the exceptions or exemptions, I'm not quite sure which it is, of Swampbuster is that if you, let's say you violate Swampbuster, not necessarily knowing that you're doing it. Let's say you drained a wetland, didn't know it was a certified wetland, and then your eligibility was at risk, you could do what's called mitigate that. So basically you can either undrain the wetland and let it return back to its normal state, or if you really wanted that wetland for that particular, plot of land that you were growing the crops on, you could mitigate and either construct or refill a wetland elsewhere. That's one of the mitigation options that's available to continue to comply with Swampbuster while still draining your wetland.
And also to us back to the plaintiff brought this case. So the owner of this wetland and the farm with the wetland is who brought the case to the court with the complaint or saying that they're like unjustly not being able to receive farmland benefits. We're not stating, or it's not us interpreting it. They made that decision to take it to the court, and as if farmland benefits and programs are of concern to them.
And to clarify too, to go to your confusion, Mary Ellen, no one ever told the plaintiff that he violated Swampbuster. No one ever told him he was losing his benefits. That it never happened. So.
Yeah, that's why I'm confused. Is there a minimum acreage necessary to qualify for Swampbuster support?
I believe there is a acreage cap or something, or minimum. I don't remember exactly what it is, but it's something like under 50 acres or maybe 40 acres. You're basically sort of exempt from the conservation compliance requirements, I believe.
Probably no minimum, but yes, a maximum, cap on a maximum.
Oh, sorry, there's no max on the cap. No, sorry, there's no maximum cap. Like you can have as many thousands of acres as you want. But if your land is 50 acres or less, or 40 acres or whatever it is, then you don't need to comply with Swampbuster as one of your eligibility requirements to get farm benefit, is my understanding. Again, as a not expert, just having as someone who has read the farm bill.
Another question is, since farmland is often rented, and by the way, somebody wanted to know, does anyone know what percentage of agricultural land in Iowa is rented? And I do not know that. I do know that 55% of Iowa arable land is now owned by women, but I don't know what percent is. I'm sure that that number is out there someplace. Is there, since farmland is often rented, who receives the benefits? The landowner or the person farming the land?
I don't know, Ellie, if you want to take that one.
I only know of personal experience, so I would recommend calling your local USDA office for more information, but I only know from personal experience.
Carolyn wants you to know that it warms her heart that you're purchasing your farm, Ellie, and settle their roots to carry on the families. Okay. Steve wants to know, it sounds like he bought this land without seeing it. You can't make much money with 71 acres if that is all you are doing with the land. Well, it sounds like he's near a town. Is that correct?
Yes.
I will say, so Delaware is not, we don't really have cities. Manchester is probably the biggest. I'm going to guess that's 10,000. I don't know if that's the correct, but it's a very rural county.
Mm-hmm.
Booming, economic, thriving place that's like growing, that this would be a hot market for building, I would say.
Kay wants to know how. Okay.
Visiting our
Kay wants to know how the plaintiff is financing his suit. Is there someone or an organization behind him? I'm suspicious. That's Kay.
I don't know how it's being financed. We just know the name of the plaintiff, and then the law firms that are involved.
Anonymous again, I don't know who this is. I thought non-operating landowners, 62% of the farmland is non-operating, could apply for CRP or EQIP. This landowner may not meet other eligibility requirements. CRP has to be through the landowner since it is a temporary easement. Plus, I thought a non-compliant landowner uses all USDA benefits, subsidies, insurance. I'm not sure what he's saying here. Oh, loses all USDA benefits. A non-compliant landowner loses all USDA benefits. That's subsidies and insurance and everything. So yes, he's not alone in having to comply with certain parameters to get these USDA benefits. I think that's what this person is pointing out, that that's common. And that also, being a soil and water commissioner, I know that we are required, the staff is required to go out and check property and make sure that people are following the requirements of the contracts they've signed and are getting benefits for. So this is a kind of a curious attack on Swampbuster that makes me wonder if it's a trial balloon, given what we do and don't know about this particular case and the fact that it's in a court appointed by current President Trump.
Well, I mean, all signs point to these judges are, you know, they follow the law, they call balls and strikes, and they make rulings that, you know, make sense and comply with the law. And I would expect that to be the case going forward. And obviously, from our perspective, our view of the law is that this plaintiff doesn't have any skin in the game, and therefore this lawsuit should be kicked out on that basis alone. Not to mention that all of those legal claims that I put up there are flawed for a variety of deeply boring legal reasons. But you know, and that's what the judge will be ruling on come next month.
We've got about 5 minutes left. If you have any other questions, put them in the Q&A. Otherwise, I'm going to give Elle and Katie time to wrap up with last thoughts.
I saw there was a question, my interest in regenerative farming practices. And yes, like I showed, we have ground and hay, especially any slopes, even slight slopes. We have in hay, which is a perennial crop. We also have permanent pasture on the deeper slopes on the farm. And we are really looking forward to bringing livestock back to the land and getting a cow herd of our own and doing rotational grazing. But we do have in crops, we rotate as well. So very concerned with stewarding the land and protecting the land on our farm, and any water that's coming onto or off of our farm, of course, is top of mind for us. Thanks for asking.
Yeah, and just to build off of that and to maybe go a little bit to your confusion too, Mary and Ellen, I sometimes get questions, well, why do the farmers want to protect it? Why wouldn't the farmers want to get free money with no strings attached? I mean, why they're, you know, who doesn't want that? And I think that what people who aren't farmers might not understand is that farmers who are landowners who view land as a short-term investment that is going to be, you know, either converted in for commercial purposes or extracted, you know, certain resources will be extracted out of for some period of time until it is sold and passed along. They have a particular relationship with the land that is almost by definition short-term and based on profit. Whereas farmers, in particular family farmers who, and in particular the ones who have been doing this for generations, they know that you can't have that relationship with land for very long or water and expect the land and water to stay around. And their investment in the land is not this short-term extractive, how much profit can I get out of it in the next 2 to 5 years? It's what can I do with it for my life and my children's lives? And that's the thing I think that I just want to make sure to pass it along, because it is a little counterintuitive, right? Who wouldn't want free money for nothing? But it's because the farmers understand that conserving the land won't be done on its own, and the farmers need to do that. And that is not only a good for the rest of us in the country who rely on these natural resources too, and the food that's grown on them, but for the farmers themselves.
I want to thank you both. This is always an interesting conversation. Again, I want to remind everyone that we did record this. It will be available on our website. I always want to remind our local league presidents and program chairs that these recordings make an excellent program for your local league program years, so do consider that. I also want to mention I had the good fortune just the other day to hear Royal Gardner speak, and I want to recommend 2 of his books. These are deep dives. These are not easy reads. These are legal treatises. But his current book is called Waters of the United States, POTUS, SCOTUS, WOTUS, and the Politics of a Natural Resource. And he does mention, you know, the Supreme Court decision in 23 that was really devastating to the environment, and by narrowing the legal definition of waters of the U.S., and it's causing a lot of consternation. Royal Gardner is an attorney. He's worked in many ways throughout Congress and the White House and various arenas. But he also wrote an earlier book called Lawyers, Swamps, and Money, which I'm definitely going to be interested in reading. But again, these are deep legal dives, the U.S. wetland law policy and politics. But again, politics is part of what we live with today, and particularly important that we pay attention to all of what's happening. Katie Garvey, thank you so much. Elle, Gadient, I'm sure my path will cross yours very soon. I'm an Iowa Farmers Union member, but just so appreciate you being with us today. And thank you all for joining us.